Hi folks, and welcome back to Innovation and IP Law. This is video 2 in the video series on licensing part 3, which deals with IP agreements and competition law. And in the first video we did an overview and we had a look at anti-competitive agreements. And now in this video we're going to kick off things by looking at the prohibition on cartels, which is in section 45AA through AU of the Competition and Consumer Act. And the first thing I want to do is note for you that all of this discussion on cartels needs to be prefaced with the comment that this is a per se prohibition. Per se prohibition. That means that cartels are prohibited regardless of what impact they have on competition. So they may not substantially lessen competition, they may have no effect on competition at all. Nevertheless, if they satisfy all of the elements, they are eligible for all the nasty penalties that can apply for cartel behaviour. So what's the provision all about? The first thing is that you need a contract arrangement or understanding, and all of the stuff that we said in relation to section 45, anti-competitive agreements, that applies here as well. So you need a contract arrangement or understanding with a cartel provision in it. A cartel provision. What is a cartel provision? It is a provision that satisfies one of two further tests. So this is an either or. Either the cartel provision has to have the purpose, effect or likely effect of price fixing. So that's the first naughty behaviour. Or it has to have the purpose of output restrictions, market sharing or bid rigging. So there's your four forms of naughty conduct. Notice that the provision is tougher on price fixing than it is for the other forms of cartel, because you can still contravene for price fixing even though there's no intent or purpose of actually price fixing, and there's no actual effect of price fixing. So long as the cartel provision would have the likely effect of price fixing, then unfortunately you're gone for price fixing. The final element in establishing a cartel is that the parties have to be in competition with each other. So this is a horizontal form of conduct that is between competitors that are all at the same level in the supply chain. So if one's a retailer, they'll all be retailers. If one is a supplier, they'll all be suppliers. So horizontal conduct here. Even though cartels are prohibited per se and very serious, they can be authorised and they can be notified. So there are those two same ways that you can get immunity that we talked about for section 45. Anti-competitive agreements are available here as well. There is a joint venture exception also, which we obviously need to know about in terms of IP agreements. That exception applies if three elements are satisfied. Firstly, the cartel provision is for the purposes of the joint venture. Secondly, it's reasonably necessary for the joint venture. And thirdly, the joint venture is for the production, acquisition or supply of goods and services. I'll go into a bit more detail in the study guide, so certainly flesh that one out. Very important one for IP agreements. The final kind of immunity that can be obtained for cartel behaviour is the whistleblowing provisions. And this is I won't say it's recent, but relatively recent, I guess, innovation in our competition law. And it's been developed and inserted into the legislation because cartels are usually very secretive and very hard to crack, and so any incentive that you can give to one of the parties to break ranks and dob the others in is going to be useful. You do have to be the first party across the line to the ACCC's office, so I guess it's a race to see who gets there first, but certainly a useful provision there. How does this conduct apply to IP agreements? Well, I've set out just a little table for you, just going through some fairly common terms and contracts that might well fit the bill in terms of cartels. So remembering here that you're always going to have the to be a cartel, you're always going to have the agreement between competitors. Okay, so that's something to bear in mind. Not as common as you might think. So in terms of A and B agreeing to limit B's output of a product, that may well constitute an output restriction that is a cartel provision. In terms of field of use licensing or field of application licensing, that may well constitute market allocation, where your parties are collaborating to distort the result of a bid. Unfortunately, that'll be bid rigging, and franchise agreements often will involve setting of prices, common prices amongst all of the franchisees, and that is very squarely price fixing. Remembering also that none of this has to substantially lessen competition. This is a per se prohibition, so it's enough that you've satisfied those three elements. So that's cartels. And next we need to look at misuse of market power. And misuse of market power is regulated by Section 46 of the CCA, and that provision says that a company with a substantial degree of market power must not engage in conduct with the purpose, effect or likely effect of substantially lessening competition in a relevant market. So there's a few different things that you need to think about there. First thing to ask is, what is substantial power in a market? And power in a market really is measured by a firm's ability to insulate themselves from competition. That is, they can act free of the constraints that would normally apply to the ordinary market competitor. So, for example, if you could raise your prices to whatever level you like without the consumer being able to do too much in terms of swapping to an alternative brand, then you may well have substantial power in a market. The Eastern Express case said that substantial power meant considerable or large, so some lovely synonyms for you again there. Essentially, as I said, it means being able to act free of constraints. Also, the other thing to realise is that market share doesn't constitute market power. So in one case that we're going to have a look at in a minute, the Millway case, the operator there had 80 to 90% of the market, very clearly market power, but there have been other cases like the Universal Music case, which we'll discuss later on in this video, and you know, the ACCC was successful at first instance in arguing that about 16 to 17% market share was actually a substantial degree of market power. So there's a fairly wide spectrum, isn't there? You've got 80 to 90% being a fairly clear case, 16 to 17% being more marginal. There's a fairly large grey area in between. Lots of different things will be taken into the mix. Financial resources, also, it's important to remember, financial resources don't constitute market power. So just because the firm has a very large market capitalisation, it doesn't necessarily mean that it's going to be market power. Of course, it'll be one of the things that the ACCC or a court throws into the mix, but it's not of itself going to constitute market power. The kinds of things that the ACCC will look at will be things like how difficult it is for competitors to enter, the business's ability to behave with little regard to what its competitors, suppliers or customers do. Market share is one of the factors, but as I said, it's not the determinative factor by any stretch. The financial strength and the ability of the business to consistently restrict competition. So that is the misuse of market power provision. So how does all of this bear on IP agreements? Well, here we have the rather memorable Millway case. A case study in stubbornness, I would wager. Robert Hicks was trading as Auto Fashion, and Auto Fashion had an exclusive distributorship from the Millway Street Directory publishers. The Millway publishers decided to segment their markets so that they could charge more effectively. So they engaged in field of use distributorships. So these agreements would allow one operator to sell in auto spare parts and accessories shops. Another would be to sell in petrol stations, and another in a different field of use. So it divided up the market that way. Poor Mr. Hicks had a falling out with another principal at Auto Fashion, and this other principal went away and set up shop. I don't know if it was across the street, I don't think it was. Set up shop in Competition. Robert Hicks was very annoyed. Millway was rather happy because they actually preferred the other guy to Robert Hicks. So the agreement with Robert Hicks was terminable at will, so they could just terminate for convenience, which they promptly did so. Robert Hicks was highly incensed and decided to, back down? No way. He actually ordered more directories from Millway. Millway then refused the supply of these further directories to Robert Hicks. So what does Hicks do? He goes and sues for a breach of Section 46, alleging that Millway had misused its market power in protecting its segmented distribution system and preventing him from acting competitively in the auto accessories market for street directories. It went all the way up to the High Court, and poor old Mr. Hicks lost out. It was found that Millway didn't take advantage of its market power. Now, taking advantage is no longer an element in the legislation currently. It was back in the early 2000s when this decision was handed down. So that's one differentiating factor to just kind of keep in the back of your mind. But the court's discussion of market power is certainly still valid. I'll just read you a quick snippet from the case. The court found, bearing in mind that the refusal to supply the respondent was only a manifestation of Millway's distributorship system, the real question was whether, without its market power, Millway could have maintained its distributorship system, or at least that part of it that gave distributors exclusive rights in relation to specified segments of the retail market. And they said, well, yes, Millway absolutely could do all of that even without market power, and they had set up their segmented distribution system before they had market power. That's one of the incidents, isn't it, of being able to license one's copyright. And so therefore Millway prevailed in the end. And I'm sure that the other director with whom Robert Hicks had the falling out was kind of smugly pleased at the outcome of that decision. So that is the Millway case, and that is the issue of misuse of market power. And it's getting close to the 15-odd minute mark now, so I think I'll finish this video here and I'll skip across to video 3. So until then, bye for now, guys.